May it be please your lordship. Lordship, I beg to mention item number 9, lordship. Matter may be adjourned for the day only, lordship.
9, no. There's no
Lordship,
previous adjournment slip. We'll see when it reaches, not now. Only there's one advance slip given for item number 6. This is the only case we are adjourning. Item 6, votes as represented on the prayer made by learned counsel for the petitioner. List after. It's a 2017 matter. You get after 2 weeks. Other matters we are not adjourning. We'll take it up and then pass orders.
May I please, Lordship? Lordship, I beg to mention for listing a WPC.
This thing, please give it to the court master.
Item 1 or motion.
I believe you. My lord, I think, yes. Did you get it?
Yes.
Okay.
Again.
Right. This is that visitation right. Heard Mr. S.A. Ahmed, learned counsel for the petitioner, as well as for the respondents. CGC is Mr. Adhikari here. Pursuant to order dated 13/10/2025, the learned standing counsel for the FT and border matters has produced a copy of written instructions dated 15/10/2025, received from the senior superintendent of police within bracket border bracket Assam, disclosing that the concerned declared foreign national, namely Muhammad Malika Khatun alias Molika Khatun, Malika Malika Khatun alias Molika Molika Khatun Khatun, 55 years, wife of late Bubul Ali, was declared as a foreigner by opinion dated 29/3/2010, passed in Jorhat FT, case number FTG, full stop 4/2007. Passed by the Foreigners Tribunal Jorhat, is held in the holding center at 7th AP Battalion, Saraikula, Kokrajhar. Stop. The said communication is retained as a part of record. Next para. Accordingly, the court is inclined to allow the petitioner and one petitioner, namely Abdul Malik, as well as one family member, to the visitation right to the said declared foreign national. Next, accordingly, it is provided that on production of a certified copy of this order, the in charge of the holding center, 7th AP Battalion, Saraikula, Kokrajhar, shall permit the petitioner and one family member to meet the declared foreign national, namely Muhammad Malika Khatun alias Malika Khatun, and to obtain her signature in the Wakalatnama. Next para. List again on 27/10/2025.
Obligement.
Item 2 for admission.
My please, Lordship. English Council is another English in another Putnam Lordship. I'll pass over timing.
Item 3 for admission.
My pleasure, Lordship. Lordship, petitioner challenged the impugn order, expired order dated 18/1/2021, Lordship, page 26.
Which is the best document you have to connect you to your projected parents?
Lordship, petitioner, initially the petitioner appeared.
Because in this case, you did not appear.
No, petitioner, Lordship, petitioner appeared with the Angus Council, but later on they have absent. Both are absent, and after lockdown they have not appeared, and expiry order was passed, Lordship, and they have the linkage documents, Lordship, because grandfather name was enlisted.
No, because that is not a good ground. In fact, in the impugn opinion,
Lordship.
you come to page 27,
Yes, Lordship.
read the paragraph. Page 27, first paragraph.
Yes, Lordship. May I read, Lordship? I have perused the case record and notice. The record reveals that on 27/8/2009, the proceeding received the notice by putting her thumb impression on the notice. Thereafter, she was present on 28/8/2009, 7/9/2019, 21/10/2019, and 20/11/2019, and filed petition for allowing time to submit written statement. However, OP proceeding remain absent on 6 consecutive dates without any states, that is on 3/12/2019, 26/12/2019, 17/1/2020, 30/1/2020, 18/3/2020, 70/2020. During COVID-19 and lockdown, 5 days were granted. Those are not taken into consideration for passing this order. Matter was fixed for expiry order on 17/4/2020. However, due to lockdown, the order could not pass. After lifting of lockdown, neither the OP nor his counsel represent her. Under such circumstances, I find no alternative except to pass an expiry order against the proceeding. The proceeding was granted sufficient opportunity to discharge her mandatory burden of proving herself to be not foreigner, as required under Section 9 of the Foreigners Act 1946. So, question of violation of national justice would not apply. The OP has totally failed to discharge to establish her nationality. This is the finding, Lordship.
So you see, this happened in 18/1/2021. But after that,
Yes,
you have come to this court after more than 4 years.
Lordship. When petitioner was not no knowledge, because after she was detained 29/5/2025, Lordship. Petitioner filed this petition, Lordship.
No, knowledge is willful absenteeism.
Yes, Lordship.
The society did
Look,
not care to
after,
find out what has happened.
Let's say after COVID situation, that's what notice may be issued to the petitioner, to appear.
No, not required. Not required.
We have
You see,
decision, we have
let us
mentioned it.
test your submissions. One of the case which is fixed today, I'm sure the lawyer will not appear. The lawyer will not appear in that matter. So when the matter is called and the lawyer is not there, should we issue a fresh notice to the petitioner?
No, Lordship, after COVID situation, if parties are not appeared, then notice may be issued to the petitioner.
That's why, in this case, you see, after getting a stay in foreigners matter, it would cause a nuisance if the lawyers will say that no, I will not appear. There's no instructions, I will not appear. Please issue notice. So we issue a notice, next lawyer appears. After 2 days, he also says that no, I will not appear. Please send notice. This would be for how long? Because we don't have
Because now
we don't have a
petitioner-
precedent which says that once the party doesn't stops appearing, notice is to be issued.
Yes, but the petitioner has no option, Lordship, in this case, Lordship.
No, but
Because petitioner
if you
has-
could have appeared in
Petitioner
on
has
time,
already handed
you would have
over the all
understood.
documents to the engaged counsel, Lordship. We have made a statement in paragraph 23 and 24, Lordship. If there is a latest document, Lordship, it's a remand document, Lordship, to provide documents, Lordship.
There is, my humble submission is that Lordship, there is no infirmity in the opinion passed by the learned tribunal. And we are here only to see whether the opinion of the tribunal is good or bad, Lordship. And Lordship, here in this case, Lordship tribunal has no stone except passing this order, Lordship. So ample scope has been given to the proceeding, and even eh, after that also more than 4 years has gone, Lordship, to approach before this honorable court. And after arrest, he approached before this honorable court. It is delay and laches will come, Lordship. Principle of delay and laches will come, Lordship, in this case. Documents, Lordship, we have annex case, Lordship, 32, annex 4, Lordship. This is 65 voter list, Lordship. Grandparents of the petitioner, Lordship. And next, Lordship, 1970 voter list, Lordship. Yes, Lordship, 1985 annex 37 page, Lordship. Page 37. Annex 6, 36 and 37, Lordship. No. Petitioner parent's name, Lordship. 37. Yes, Lordship. His mother's name is Khatija Banu. Parents is Umar Ali and Lordship, my single name is in 2016 voter list, Lordship, page 47. Azufa Khatun. Along with her.
Wife of husband, Lordship. Wife of Abu Kalam. At that time, my name was not enlisted with my parents. We annex certificate of Gram Panchayat, Lordship. If, no, Lordship. Okay.
Timing item 2.
May I please, Your Lordship? Lordship, in this matter, Lordship has trial court record was given to the standing council to Your Lordship for regarding verification, Your Lordship. Two brothers of the petitioner, Your Lordship, have been declared Indian by the same tribunal. And I have annexed these orders, Your Lordship, by additional affidavit.
Yes, yes.
First of all, my submission is that, my lord, each and every case that has to be looked separately. Because each and every case, my lord, their facts has to be looked separately. Because, my lord, recently Supreme Court has said, my lord, in Abdul Quddus itself, it is said, my lord. One brother may come earlier to 1971, one may come after 71. So in that case, my lord, even though they are, my lord, relative or brothers, each and every case that has to be appreciated separately it has to be looked, my lord. That is the first point. Secondly, what I have gone through, my lord, I have gone through the record. It is my lord, in the initial WS filed by the petitioner, my lord, there was no statement that he has any brother, she has any brother or sister. In the initial step, my lord, WS. Then she filed an additional WS letter part, my lord. At the same time of filing the WS by the, my lord, the brother, projected brother. There she has pleaded that she has brother of so. Now, in fact, in the both the case, my lord, I have seen, there is no disclosure that they have case pending in the same tribunal. Had it been disclosed, my lord, though both the matters were running in the same tribunal, had it been disclosed, they did not disclose that their cases are pending both in both the respective, my lord. There is no disclosure that the case is pending, either side. Now, even though I'm not, my lord, the projected brother's case, I have checked it out. He has some document. Apparently, he has some documents on the basis of which, my lord, he may have been declared Indian. I have seen a land documents, my lord, where the father, projected father, and the, my lord, the person concerned, who is not a petitioner here, the brother, is in a common, my lord, patta. Both of them in a common patta. Probably for that reason, my lord, he may have been declared Indian. I am not going to argue on the merit of that case, my lord. Probably for that reason, my lord, it can be accepted. But in this case, there is no link document at all. To project, not, it is relied, but there the petitioner's name is not there. There the petitioner's name is not there. And it is not this pleaded case that her name is also there in the same, my lord, the Jamaban. So that is the brief point, my lord, the unfulfilled. Other we can see in merit, but what is the similar, my lord? The documents which are relied later on by the petitioner, those were brought in the second WS, my lord, the additional WS, which was filed just 2 days before, 3 days before, 4 days before filing of the WS by the, my lord, the projected brother, not in the initial WS. In case of Amina Begum, my lord, the petitioner, WS is at page 44 of the, my lord, record. And in that case, merit also, my lord, the petitioner said that she was specific, pleading that she was born in 1960. And her first voter list is of 1997. That is, my lord, if she was born in 1960, she was eligible to cast vote in 1981 itself. From 1981 to 1997, there is no voter list at all. So her first voter list, either with the parents or with the, my lord, husband. So her first voter list is 1997 voter list. And she filed additional WS, that is on page 53, madam, additional WS. Page 53 in the record of Amina Begum case. There on in para 19, he has described, my lord, about the land.
This is. Yes. একটু এখনো লই যাও একটু that only flag one,
Yes,
only one document. Same document is here in the second flag.
yes, I admit, my lord, this document is there.
Look at second flag. Yes. Now look at the endorsement down below in that page. No, no, same page, down below. Therefore, the tribunal is aware that both documents are being used.
Original submitted.
In FT 350. The other file is 350. And the state did not file any appeal in respect of the brother, saying that the sister has been declared as a foreigner. This petitioner would have, must be given a chance.
In that case, my lord, if your lordship permits, my lord, one thing I can submit, I may submit. Because in such cases, my lord, where your lordship is remanding the cases of the my lord on the basis of some other judgment of my lord brother and sisters. In that case, my lord, we have some cases, your lordship will know, man. Where my lord, the show motor writ petition has been registered in another case, and both the matters is sent together, sent back for fresh.
No, the state did not file an appeal.
No, that
We
is-
are not
that is-
registering a
that-
suo motu
No, I know, my lord.
challenge.
That has, in all those cases also, that has not filed. But as they are taking benefit of that my lord judgment, that
No, you
opinion of.
see, your government leader appearing in that case is aware. That's why we were searching for that.
I don't know, my lord, because the
Something-
record reveals the name, the case number is written. But my lord, it is also my submission with that they should have informed it properly while filing WS and other aspects also. They have not disclosed, my lord, all these things. Because this endorsement is, my lord. I may not take, my lord, this and
The endorsement has come on the document.
Yes.
It says that the original was there. Now look at the trial court record. Was the original returned? Original exhibit in that 350? Is there in the order sheet? If the original document is not there. Last order would be
original
that the,
documents are not came out.
no, the last order would be that the documents are returned. There must be some order returning the document.
Yes. If I have not seen, my lord, the order of returning the original.
Maybe-
This. And one aspect I have seen, my lord, in both the records. All this, both the documents, in both the cases, documents were, my lord, inspected on this, signed on the same day,
Sign on the same day.
same. Day. 6/8.
It'll take us some time to go through the records. If we'll take it as a parted matter after a week. Since you say that both the documents were signed on the same day.
Yeah.
we'll just verify the records. That's it. Also, as presented, the matter has been heard in part. Full stop. As the records are voluminous, to take some time to peruse the records. Accordingly, it's the matter again on 28/10/2025 as part of
2010.
28.
28.
80.
2/8, my lord.
28.
Obliged.
My lord, records were given to us by.
Just,
That may-
the learned standing counsel for the FT and border matters has returned both the records of the tribunal.
Obliged.
Item 4 for orders.
Legal office. Lordship, can it be taken after something? Just for the time.
supplementary item for orders, item 11 with item 12.
In this matter, my lord, I have received instructions to you. Now, should make kindly see para 4, my lord. The third line from the bottom. The yes, my lord. It is there, my lord. Let me get the file. It's outside now.
Yes, madam. Madam. Look, what my understanding is, uh, this is my technical part, in fact. This all these writings and my lord, this comparison are done by the clerks only. And he just put this signature. That is the problem there, madam. Probably in the trial courts, that is the general procedure. So the use of yes, same document, signing on the same date, my lord. I don't know. Both the cases were not on the same date, probably. But how he has signed both the cases, and that is also another aspect. Yes, because both the cases were not fixed on the same day. Despite of that, both all the documents were signed on the same day. So there are some situations which cannot be explained here. In fact, my lord, had it been described somewhere disclosed, it could have been, my lord, Now it is 11:30. Item 13.
May I please your lordship? Wait for some time, my senior is coming.
In this, on a file, today, he hasn't got those documents. But can it be tomorrow? Because other matter is also has come up in the list tomorrow. Similar matter, yes. Yes, yes. Put it in requirement, yes. Yes. Tomorrow. Malad, इस तारीख को चलिए, 28 तारीख वो कल वाला प्रॉब्लम हो गया अप्लाई
Item 13.
May it please your lordship.
Lord, the 4 years baby, my Lord, I am the natural father. My Lord, it has been in illegal detention. My Lord, our petition was that respondent number 4 took away from my premises when I was in a custody. Now, when I came from the custody, then the people nearby informed me that respondent number 4 came and took away. Now, these amounts to, my Lord, either illegal detention or kidnapping. Now, therefore, my Lord, we informed the police. Police did not do anything, and ultimately we had to come before your lordships. And in terms of, my Lord, Minority and Guardianship Act, Section 6, the father is the natural guardian, and it is obvious that he has to get the custody of the girl. She is aged about 4 years at the relevant time, and my Lord, obviously, she did not have any baby is with the respondent number 4 initially. Now, by filing in affidavit, they have stated that now she is with Tilottama Hazarika, said to be a maternal aunt. Now, under what provision of law she has taken the position of the girl? That's the question. Yes, yes. My Lord, she committed suicide. Yes, yes. Baby has been taken away, my Lord, when she committed suicide. Mother of the baby is Arpita, my Lord. Sorry, mother is Anuradha Hazarika. Arpita is the baby. Who, my lord? No, she is not alive. My lord. She committed suicide on 17/6/2024. She born on 6/5/2020.
of 2018, Your Lordship. Your Lordship, from third para, Your Lordship. It transpires from the material on record that a petitioner appeared before the tribunal on 29/11/2017. If Your Lordship got it, Your Lord. Consequent upon receipt of notice. On the said date and on a petition submitted by the petitioners, he was granted bail. Record show that on and after 29/11/2017, the petitioner did not appear before the tribunal. In such a situation, the tribunal had no other alternative but to bring the reference case to a close by the order dated 21/3/2018. It also appears from the record that the petitioner, through her engaged counsel, was taking steps seeking adjournment to file evidence in chief. We cannot be oblivious to the fact that the procedure for identifying and for declaring a person to be a foreigner illegally entering into Indian territory cannot be a mechanical exercise. A burden is cast upon the person under Section 5 of the 9 of the Foreigners Act 1946 to establish that she is a citizen of India. In the instant case and on the facts appearing, we are of the considered view that for the ends of justice, at least one more opportunity should be granted to the petitioner to discharge her burden as required under Section 9 of the Foreigners Act 1946, Your Lordship. So, Your Lordship, I'm also praying in this case, Your Lordship, for the ends of justice, Your Lordship, at least one opportunity may be given, Your Lordship, since he has got several documents, Your Lordship. In Junu Begum, Your Lordship, it is related to certain documents which he could not produce, Your Lordship. 4991 of 2020. If Your Lordship may go on to para 6. Para 6, Your Lordship. Learned counsel for the petitioner submits that there are sufficient documents available with the petitioner to show that she is a genuine citizen of this country. However, because of the negligence on the part of her counsel, she could not produce those documents before the tribunal. That is the copy of documents including the voter list of 1966, 97, 2009, 2010, 11, 15, and 19, marriage certificate, residence certificate, etc. Learned counsel for the petitioner accordingly submits that serious prejudice will be caused to the petitioner if the petitioner is not granted another opportunity to prove that she is an Indian citizen, not a foreigner. Having heard the learned counsel for the parties and also on perusal of the material on record, we are of the view that the petitioner, under the circumstances narrated above, may be granted another opportunity to appear before the Foreigners Tribunal, Jorhat, to prove that she is not a foreigner but an Indian citizen, Your Lordship. Your Lordship, in my case also, Your Lordship, since there are several documents, Your Lordship, which needs perusal of the learned tribunal, Your Lordship. And Your Lordship, prima facie, Your Lordship, I have a case, Your Lordship, where I can link myself with an Indian citizen prior to 1971, Your Lordship. So for the ends of justice, Your Lordship, I may be allowed one more chance, Your Lordship, so that I can prove my case before the tribunal. Yes, and Your Lordship, I'm just since Your Lordship, in this case also, there is another Arufan Lojo. The Arufan Lojo. No. Arufan Lojo. Bharati Ravi Das, Your Lordship, since I am also stressing, Your Lordship, that the verification clause, Your Lordship, since it was held, Your Lordship, the Foreigners Tribunal Order 1964, Section 3(1) was hardly seen to be complied with, Your Lordship, in many cases, Your Lordship. Thereafter, even in the full bench judgment in Muslim Mondal, thereafter, even recently, Your Lordship, in Abdul Rahim, this has been reiterated, that material the materials which, for which a person has been suspected to be a foreigner has to be provided to the, that person. Now, leaving that material, Your Lordship, proper inquiry in many cases has not been done. Similar is in my case, Your Lordship. And in such similar occasion, Your Lordship, circumstances, Your Lordship, in Bharati Ravidas, our honorable court, Your Lordship, in may I draw Your Lordship attention to para 5 and 6, Your Lordship. We have also taken note that in the verification report leading to the reference against the petitioner, it had been recorded that the address of Bharati Ravidas is at Kalruba, her husband name is so-and-so, and she was born on so-and-so. The report also stated that the authorities visited the house of the proceedee on several occasions, but she could not produce any document. No information is recorded in the verification report, which may indicate the reason as to why the authorities thought that the petitioner is a person who entered the Assam or state of Assam subsequent to 25/3/1971. In fact, even the column providing for place of birth is also vacant and not filled up. Conjointly considering the aspect that the verification report itself is incomplete to lead to any conclusion that the petitioner is a person who entered the state of Assam subsequent to 25/3/1971, and further that the evidence of Ram Prasad Ravidas, who could prove his citizenship, has deposed that the petitioner is his daughter, remain uncontroverted. We are of the view that the reference made against the petitioner itself would be untenable in law. So, Your Lordship, I am a victim, Your Lordship, because Your Lordship, proper verification has not been done. My place of birth, my actual residence was not stated in the verification report. Karbi Anglong being a 6th schedule area, Your Lordship, we just go there, we do our business and we return back, Your Lordship. We don't have any permanent resident there, Your Lordship.
My lord, this is a review jurisdiction, my lord, first of all. This is not the hearing of the original writ petition. So we have to see on the view, my lord, limited aspect. What is the error apparent in the past record in the, my lord, the order passed by this honorable court, my lord? And if I show, my lord, my learned friend has argued, given a ground that my lord notice, second time notice was not served properly, that ground was there taken in the writ petition itself. And that is dealt with by this notice. If he's not satisfied, that he can go to approach the Supreme Court, but this is not the forum for reviewing, because that has been dealt with, madam. In the judgment itself, in para 3, 4, and 5. Para 3, this point was there, madam, that notice was served earlier. Then in the next time, no notice was served. He was not informed by the Kavra. All these things are there in this para, in the earlier judgment. This is taken care of, madam. Only after taking care of all these facts, my lord, whatever my learned friend has submitted, this judgment is passed. So what is the error apparent on the face of the record? There is no error apparent in the judgment, madam. It is not that these facts were not taken care of in the, during passing of this judgment. These facts were taken care of, and after taking care of all these facts, my lord, this judgment is passed. And second aspect, my lord, my learned friend is arguing on merit. That has not yet come. It's an expertise order. He did not appear. He did not appear. He appeared first. He deliberately did not submit the written statements and this evidence. Then, my lord, those were the days, my lord, when, in fact, those matters were filed up. It should not have been filed up. It should have been decided at that time itself. Even then, those matters were filed up even after their appearance. My lord, your lordship has recorded in the earlier judgment that, my lord, he filed petition at para 8 of the, my lord, judgment, he filed petition for seeking time to file evidence in W. Then after, why he was missing? He did not care of this petition. He did not care. Para 8, my lord. And how this matter come, my lord? Initially, when he was picked up, he approached the Honorable Court by filing another petition. Habeas corpus. Habeas corpus, no, habeas corpus, no. The fact that, my lord, he has numbers of documents of his own to establish his citizenship, that is was also there in the writ petition. This is a good point. This is a rehearing of the, my lord, writ petition again. And with regard to, my lord, principle of natural justice, it is second time also, my lord, it is not only that he was not given, my lord, notice. Second time also notice was served. Of course, it was 5 minutes substitute manner. Substitute manner, that is as per law. So, my lord, if it is so, my lord, first time his notice was served properly. He accepted notice. He appeared before the tribunal. He submitted petitions, my lord. Second time, if he is interested, my lord, he is really bona fide, my lord. If he is coming with bona fide, my lord, manner, he should have informed that I am shifting this place. He has never, this is the, my lord, it should not be only one-sided, my lord. It is duty casted on them also, that while shifting it during, even after inquiry also, if he shifts his residence, he has to inform the inquiring official. But here, my lord, it is not only after inquiry. After the proceeding is initiated before the tribunal, when he filed 2-3 petitions seeking time for filing evidence in WS, my lord, he is not filing. Now he is saying that I have shifted. I should be served notice in the new address. How can the petitioner of the court know, my lord? The tribunal will know that he has shifted it to new residence. These are facts, my lord, and in fact, these things were argued in the earlier occasion also in the writ petition. After considering all this aspect, only this honorable court passed this order. So this is not a case of review, my lord, my humble submission. And other aspects, my lord, with regard to this, because this is an expert order. If he is, my lord, had he been filed, my lord, WS and evidence, that could have been a different issue, my lord. Then it could have been decided in the merit. Those things were never. My lord, we take it to again. In fact, we submit this again and again, my lord, on a few line of this judgment. It's a old judgment, my lord, 2016 1 GLT 273. Because 2016 1 GLT 273. Ayub Ali and others versus Union of India. This was a writ appeal, my lord, wherein the judgment of the single bench were silenced. There the single bench opined, my lord, that was affirmed by the division bench. In para 16 of the writ petition, my lord, that petition, my lord, writ petition. Para 13 of this judgment, my lord, it is quoted. Para 13 of this judgment quoted the, my lord, quoted, and they are in para 16, internal para 16, 15 and 16. Para 16, my lord, I am reading this. Principle of natural justice cannot be put into a straitjacket formula. Obviously, we are following the principle of natural justice and ends of justice. It is more than 3 decades that the issue of influx of foreign nationals has been in public domain in the state of Assam. Process of determination of question of citizenship cannot be one-way traffic, leaning only in favor of the person whose citizenship is doubted. It cannot be, my lord, lean only towards the citizen, my lord, those persons whose citizenship is doubted. Interest of state is also paramount importance in the unabated influx, has potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should jealously guarded. However, if a person does not take a step for safeguarding his interest, he does so at his own peril. Right to a fair hearing or principle of natural justice cannot be permitted to lead a pharisaical situation and to be an engine for defeating the very object of identification and reportation of the political. So only on the ground of principle of natural justice, it should not always lean only towards the matter citizen whose citizenship is doubted. So it should be balanced equally. This has been affirmed. Had the person would not been arrested, my lord, this time for deporting, he would not have come. He thought that, my lord, he has escaped somehow. By filing petition that I will file evidence, he will not file evidence. And now he will say that, my lord, I may be given notice into my new address. I have said that my address complete. This is a, my lord, in fact, initial writ petition was that he did it, my lord, the sons and daughters, they came before this honorable court saying that they don't know whether there is any case pending. They have been detained, and whereabout we don't know. That was the initial submission. When the record come out, then only they are, after disposal of that, they are filing the plea. So this is only for, my lord, only a game whereby they are playing, my lord. So my submission is that, my lord, on merit, this is not a ground for review. If they are not satisfied with the judgment of the honorable court, my lord, they can definitely approach you. But this is not a ground of it.
Lordship. Lordship, before winding up, your lordship, my friend is pushing me to the apex court, your lordship, but I have got a forum here, your lordship. And the honorable apex court also in many occasions, your lordship, has stressed on filing a review petition before approaching here, your lordship. But your lordship, but I object on some of the language, your lordship, that he is playing game, your lordship. He is prima facie, he may have there might be some procedural lapses, your lordship, but prima facie he has got documents, your lordship. The sons and daughters have not said any lie. They were unaware why their father has been picked up, your lordship, and they were unaware why he has been kept and where he has been kept. So they have filed a habeas corpus petition, and while inquiring, they came to know an ex parte order has been filed. And I'm again on that, your lordship, that since your lordship that proceeding was kept filed up, your lordship, and he was even in the year 2014 he have filed a petition, your lordship, and thereafter 7 years the case was kept pending, your lordship, and after 7 years, your lordship, the rightly fresh notice was issued, and your lordship, the conduct of the proceeding, your lordship, ought to be drawn since the second stage of the proceeding, and your lordship, since he have drawn your lordship attention to 2016, your lordship, your lordship, I will again stress to the fundamental of the case, your lordship. Why, your lordship, proper inquiry has not been done, your lordship. The statute clearly says, your lordship, materials has to be provided. It has been held by the Muslim Mandal case by the full bench of this case. I'm now putting forward, your lordship, the Abdul Rahim. I have just one copy, your lordship, now, your lordship. Abdul Rahim case, your lord. From para 33, your lordship. For the sake of time, your lordship, I'm taking your lordship to para 33, your lordship. Section 9 of this act stipulates that if in a case not falling under section 8 of the act, any question arises as to whether a person is or is not a foreigner, or is not a foreigner of a particular class, the person concerned must prove that she is not a foreigner or not a foreigner of that particular class. This provision prevails notwithstanding anything in the Indian Evidence Act 1872. However, the question is that does section 9 of the act empowers the executive to pick a person at random, knock at his her dear door, tell him her they them, we suspect you of being a foreigner, and then rest easy basis section 9. Let us contextualize this to the fact at hand. The originating point of inquiry is the SP Border Nalbari's direction to Sub-Inspector Datta on 12/5/2004. The pleadings and the records are silent as to what was the basis of the SP Border Nalbari's direction, what materials or information had come to his knowledge or possession that warranted his direction. Obviously, the state cannot proceed in such manner. Neither can we as a court countenance such approach. Your lordship, rightly, your lordship, my friend says that it cannot be a one-way traffic. But your lordship, unfortunately, your lordship, it has been in one-way traffic most of the time, your lordship. Para 35, your lordship. First, it is for the authorities concerned to have in their knowledge or possession some material basis or information to suspect that a person is a foreigner and not an Indian. In the present case, though it is mentioned that from inquiry it was revealed that the appellant had migrated illegally to the state of Assam from Bangladesh after 25/3/1971, but nothing has come on record to indicate even an iota of evidence against him, except for the Bayal allegation that he had illegally migrated to India post 25/3/1971. It is also not known as to who, if any person, has alleged that the appellant had migrated to India after 25/3/1971 from village so-and-so, police station so-and-so, Memansingh in Bangladesh. It needs no reiteration that a person changed or accused would generally not be able to prove to the negative if she is not aware of the evidence material against him, her, which leads to the person being labeled suspect. Ipso facto, just an allegation, accusation cannot lead to shifting of the burden to the accused unless she is confronted with the allegation, so as also the material backing such allegation. Of course, at such stage, the evidentiary value of the material would not be required to be gone into, as the same would be done by the tribunal in the reference. However, mere allegation that to being as vague as to mechanically reproduce simply the words which mirror the text or provision in the act cannot be permitted under law. Even for the person to discharge the burden statutorily imposed on him by virtue of section 9 of the act, the person has to be intimated of the information and material available against him, such that she can contest and defend the proceedings against him. Your lordship, even if we assume that a notice was issued correctly by hanging, your lordship, there is nothing on place on record, your lordship, that proper inquiry has been done and whether materials has been served along with the report that certain evidence has been found that he is a suspected foreigner, your lordship. So, your lordship, that the basis of the case, your lordship, and in Bharati Ravidas, your lordship, our honorable court has said that when the reference itself suffers from lacuna, your lordship, that The proceeding is untenable in law, your lordship. Right. Your lordship, I am also drawing your lordship attention on the voter list of 1985, your lordship. It was found later on, your lordship. It was not annexed to the writ petition.
My lord. Yes, my lord.
No, but this,
Golaghat
there is,
59.
the
Golaghat-
Golaghat, Shivsagar and Jorhat. Golaghat.
Yeah.
Yes. Huh? Yeah, okay.
Yes, my lord.
Yeah. Right.
Okay, 29th March 2010. Yeah.
Its opinion is of 2010, my lord. Probably, yes. Golaghat.
Golaghat.
No, that's why, my lord, of 2010. Yeah, Golaghat of the second. Probably at that time, the Golaghat, there was a tribunal and that has been merged later. We don't know. That's, this is because copy has been obtained from Jorhat, but the nomenclature of the foreigners tribunal, Golaghat.
Oh, yes, sorry, my.
It will put to Mane Golaghat, Jorhat, no? Confirm. No, let us see.
For the petitioner,
It is Golaghat. At that time, Golaghat tribunal was there. Now it is merged with Jorhat. नहीं साहब adjourn.
Yes. Yes. Yes, we are there. Yes, yes.
Item 7 for hearing.
You see, there are few things. Yesterday also we made a mention. You see, there are few things we don't, we are not, especially in this bench, we are not taking so much of very harsh view. But please tell me, even yesterday we pointed it out, we are repeating it again. 61 to 65 of the Evidence Act. The requirement of proving a certified copy, for that you'll have to introduce it as a secondary evidence. You have to lay down the foundational facts of why a secondary evidence should be taken into consideration. Nothing is there in this record. Why would a certified copy be admissible in evidence? Those foundational facts are not there. In your written statement, you have given one line. You say that Annexure 9 is the Xerox copy of land document in the name of Muslim Ali alias Bolame of the year 1968. That is the only line you say. But in the evidence, that foundational facts is not there. You see, that's why we gave you that example, 12,220 books, and you tell us. No, let us say that let us say that for some reason you have exhibited this book. It has 1100 pages, you exhibit this book. Is it not required that the entry should be marked? Because then if you say tomorrow that Lordship, we had exhibited this book, and in page 870, this word was there and you missed it out. No, we understand, but you see, unless you tell us, I am. Where? Very Uh, Sir Sharma, please consider this. I think these documents. We are sending you the record at page 24 of the trial court record. page 24 onwards, you see, this is the, yes, this one. You see, everywhere he writes, Bolai, so-and-so, Bolai Muslim Ali. You've seen that? Next page, you see, that is the notice. Bolai Muslim Ali. Next page, even during the inquiry, he gave the same name of his father. In the inquiry also you have seen, he gives the same name. See, this is not something which is of the cuff argument. No, that's okay. But there's a land document. No, that is not 1990, I think 1970 or so. 19. I may be wrong. English and Assamese, maybe I am. In the left side, you will find the date. No, in the same page, first page. Left side is the registration date, right side is the certified copy date. '90. Okay. Okay. 1990 document. 1990 document. No, if there is no connect, you should, are you following the argument of Mr. Sharma? You see, your continuous stay is something which is covered by section 262 of the Citizenship Act. So therefore, the argument of Mr. Sharma is, in short, that document of 68, and then there's a gap till 1989. There's nothing in between. Your continuous stay of India is not there. Therefore, your entry from the specified territory is quite possible. So therefore, your every argument will fail. You see, the second point which we are trying to ask you is about the certified copy. If it is a post 1990 document, post 71 document, then how far it will help you? We don't know. Mr. Sharma says that it's 90. No, then there's again a problem. No, then there's a problem. Okay. No, that's how. That's how. Mr. Mazumdar, in view of that, we are adjourning the matter. You try to find out answers. Because otherwise our opinion would be against you. The fact that if the land document is of 68, then there is no Jamabandi to show the antiquity of the land. Therefore, everything will fail. It's not the matter, you find out answers and then tell us. Second thing which we'll have to answer is with regard to the admissibility of the certified copy. Even if you omit the voters list, but then sale deed or agreement for sale. You have the record. No, just see the first flag, second flag. No, so sorry, first flag, the evidence on affidavit, that part. Second flag, the evidence. Now this exhibit 5, what is written in Assamese? Now you see the problem. The document which you have exhibited is a sale deed. It's not an agreement for sale. Your evidence is contrary to the document. Your lawyer did not have time to read what he is writing. He had a very busy lawyer. We adjourn the matter. You have a point with regard to that inquiry. Your father's name is given. We are just adjourning it to liability to find out. We give you an opportunity to Mr. Mazumdar, Mr. Sharma. Let him find out answers. Because if it is agreement for sale or sale deed, then without introductory facts of section 65, secondary evidence, how it could be led, you'll have to tell us. Also, is represented on the prayer made by Mr. L.R. Mazumdar, learned counsel to the petitioner. The matter has been adjourned today. List again on 28/10/2025. He's in custody, we can't help it. We just extend the order that not be deported. In this IA, you can pass a common order in 2 IA. Both sides are represented. The prayer for consideration of the interpreting application is adjourned in view of the order passed today in the connected writ petition. List on 28/10/2025. I didn't get you. Oh, you want to read the LCR? Huh? Please go ahead. Go to it. Go to it. Go.
Item 8 for hearing.
These are very sad state of affairs. This case which we are now reading. Item 8. In
Item 9.
His senior counsel is on Lake Road. Not in your number.
Item 14.
Yes. Yes, Lordship. Yes, Lordship. I have informed. I have
Item 1.
Well, as per the Lordship has recorded the timeline given by us. As per the timeline, the Maibong PS case number of 6/18, their the investigation has been completed on 31/8/2025. And in the second case, they have said that on 31/12/25, they will 31/10 they will complete the next case. October. Lordship, there we have prayed for 60 days time.
Lord. Only the compensation.
Another fair and speedy, after your lordship intervention, your lordship now, yes, yes. Yes, yes. Lordship. Yes, yes. In the meantime, if I run it fair, can get some instruction if any compensation has been paid, because there were 13 people were injured in the. And I will take instruction more from my client. He has. Yes. By the next day, I will also take instruction from my client.
Six.
Yes, lot.
No.
Yes. Okay.
I have given a copy of my letter to him. I'll lodge. I'll get the copy. Lodge. It will be Haflang Court. I'll inform. Yes.
Yes.
Lordship. True.
Today, I think we attend our. Your lordship is here, hearing this. I'm trying to ensure this my name doesn't go there. But my lord, there is another aspect. Sometimes people want to become by doing negative. By doing negative things, people want to become popular. I'm very unclear otherwise. There's one way of becoming. That is very careful about that. Oblige.
For judgment, WPC 5582/18, item 1. Item 2.
very concept. Service the data concept.